All right, this is LAWS12066 land law, and this is the first Zoom session for land law, and this is covering topic 1, which is the nature of land, real property law, and the Native Title Act 1993. And in this tutorial, we hope to be covering the tutorial problems at the end of the notes and posted on the Moodle website. But we don't seem to have many students with us. Grant's there. I'm not sure he hasn't responded to my requests for information yet, but anyway, he's there. I think he's indicated he's coming and going. Margaret is there, but she's just left briefly. Maybe Friday nights is not the best night to choose. I'm sorry about that, people, but that was the night I chose, so we have to live with it. All right, so in terms of the nature of land and real property and native title, this topic is really, there are 3 parts to it, where I'm just allowing you to think about the concept of land and what that means. We sort of explored that, of course, in the context of the conceptual and the theoretical nature of property in LAWS 12065 foundations. But we just want to ask the question: well, what do we use? What do we mean by the concept or the word land in law specifically? What is and then to proceed on from that to look at and to explore a bit the nature of real property law in Australia. Do we have a unique real property law? What does that mean? How would one argue that it's distinguishable from its English antecedents, for example, the legal body of law from which Australian property law emerged? And then to move into consider more in a stronger way the idea of native title, but as regulated under the Native Title Act 1993. We've seen native title before in foundations in a couple of topics in the context of tenure. We saw it there, how native title has the recognition of native title has impacted upon our understanding of the doctrine of tenure in Australia and what that means. And then also in a subsequent topic in foundations, we looked at Indigenous land claims and Indigenous land rights and the emergence of the common law recognition of native title under the historic Mabo case. But the focus here in this topic in land law is on the native title legislation 1993 as amended following the Whig People's decision by the High Court. So that's where we're going. Now, is anyone there, or am I talking to myself? You're there, Grant. Are you online? Well, this is going to be a rather short tutorial. Look, I've just to let you know that I've done some recordings via the Echo 360 software, which CQ now uses, on this topic, and they hopefully will be uploaded to the website soon. The Echo 360 is good because it oh, Grant, are you there? I have a red background. I don't know what the red background indicates. Very red background. Okay, so the Echo 360 software allows me to do recordings, and then when I publish them, they get uploaded directly, hopefully, to the course website. And it's a much more seamless process than is the case with YouTube. Oh, you've got your sound off, Grant. Okay, you can turn it on if you like. It's okay. So those presentations, so that's where I'm going to use that mechanism to do some presentations and cover the material in that way. So I don't want to do that in these classes. These are more intended to be applied. I will just say a couple of things about the materials. You know, land law is a big course. Okay, and I can't, there's no shirking that. I mean, foundations was pretty, significant as well. I think that's, everyone would agree with that who's done foundations last term. And of course you needed to do it because it's prerequisite for this course. But land law is a big course. And look, all of the topics we're doing are pretty substantial. I've started the course with this link between the concept of law and native title because I wanted to, build our understanding of native title in this way over a few topics between the courses. But once we move beyond this course, then we're really into, for the next, the balance of the course up until the last topic, which again is a bit of an innovation of mine and an interest of mine, that is in social housing. But the balance of those topics, progressing through the weeks on the Torrens system of land title registration, exceptions to the Torrens system, priorities under the Torrens system, the rule against future interest and rule against perpetuities, co-ownership, leases, mortgages, easements, covenants. This is the standard template, if you like, of a land law course. But each of these is most of those topics in terms of the material to get through is pretty substantial. So, for example, in the casebook on the Torrens system, 140 pages, I've divided that into 2 weeks. It's just too much to cope with absolutely in 1 week. So we've got the fundamentals of the Torrens system and indefeasibility of title in the first topic 2, then exceptions to indefeasibility of title in topic 3. Then we've got equitable interest and unregistered interest rather and priorities, which itself is a substantial topic and a substantial body of materials. There are 100 pages in the casebook. And progressively others. Leases, a very substantial topic as well, over 100 pages in the casebook there again. So look, it's quite a lot of reading to get through, particularly the cases, and getting some feedback from foundations is, some people find the casebook a bit challenging because of that method of learning. Somehow, for some students, seems a little bit disjointed. It would be better to have a more principles basis of learning. Well, that's just the way law is. You have to learn it from the law. You have to learn it by reading the cases and struggling through how the law emerges. But what I would say is I've prescribed this time the textbook, Australian Real Property Law, that goes with the casebook. And so you can move between these two. And you can go to the textbook, give you a bit of guidance, see my notes, go back to the casebook, read a few of the cases, and move between these sources. Go to some of the, I've also referred to Peter Butt's seminal reference book, Land Law, 2010. It has a bit of a New South Wales focus, but that's a reference book. There's also Chambers, by the way. I didn't add Chambers to the list, but many of you will have purchased Chambers for foundations. And there is a topic. I mean, it wasn't adequate enough to provide an adequate reference for this course, but there is a topic on the Torrens system, and he does deal discreetly with a few of the other things we deal with in the course. So that's another source you can go to, as well as the variety of other electronic, video-based and other types of material that I'm giving you via the website to try and make the course as vibrant and as interesting as I can, and to basically tease it out of itself, if you like, and bring it to life for you. But we can't resile from the fact that there's some hard yards to do in land law, and we also have to develop some pretty robust legal problem-solving skills around land law problems. And that's what we plan to do as we progress week by week through the course. All right. Grant, are you there? No, Margaret's back. Ah, very good. I've been trying to speak to Grant, but I don't know if he's there or he's got his mic muted. I think he's in and out with children and so forth. I just given a bit of an overview in terms of the topic and also where we're going in the course, and just indicating that it's a pretty big course with a fair bit of material in each topic. I'm trying to give people the best guidance I can, not only through the notes, but just in terms of how to work between the two prescribed books, the case book and the textbook, just to get a clear understanding, but also to work through the body of law, which has emerged over time and which itself is not always straightforward, by all means, not at all. And that's just, when learning this area, that's just something you have to grapple with as we progress. We want you to have a good understanding at the end of the day, but it is a grappling process, basically. I put it any more significantly than that. The other thing I just mentioned too is that I am doing recorded presentations through the new Echo 360 technology that CQ now has. And they'll be uploaded to the website when they're done. I've done them for this week, this topic, and they should be uploaded to the website soon, I hope, once the publishing process can run its course. So you'll have those in addition to the Zoom tutorials. All right. Why don't we go to the tutorial problems? Now, I know, Margaret, I know you've got sound because I spoke to the beginning of the class. I know you've posted a response to tutorial problem 2. Any thoughts on tutorial problem 1?
For the life of me, I could not find that quote on that page.
Oh, is it? Seriously?
That's why page 21 of Australian property law.
Did I give you the wrong page? Maybe I did. Oh, let me have a check. Don't tell me I chose the wrong. I don't know. Not on the page. Don't know why, not on the page. Maybe I got the pages mixed up. Where is... Oh, no, it's not there. Oh, we won't worry about that. So, okay, but it's not, can't find it on the page. But in terms of just maybe engaging with it a little bit, Australian real property history may be seen as a triumph for efficiency of land use over attempts to provide greater equity through the distribution of land rights. So this tension between a focus on efficient land use as opposed to the equitable distribution of land rights, any thoughts on that?
Well, just in looking at the efficiency of land use, the drive that was on for land in the early parts of the colonisation of Australia, and the push for leases, whether they be pastoral leases or whatnot, that certainly, I think, drove the impetus of the laws that were in place, more so than any idea of equity around or how it might be applied to various parties and interested parties.
Yeah,
I think the whole thing was about opening up new lands for development and settlement.
And if I can respond to that, has anything changed?
No, not really.
That's right. So this is the reason I put the question there, and I'm sorry if the page of reference is not right, but the reason I put that question there quite deliberately, because this is an enduring tension. It's an enduring conflict, okay?
Yeah.
And it's not that, you know, we want to understand the characterisation of this idea of efficient land use as, you know, the big bad bogey that we need to constantly be, you know, intimidated by. But it's a question that this strikes at really, in truth, more fundamental tensions within the nature of any society. The interesting thing, of course, is that land, you know, we will go in as we proceed through the course through all of the, you know, the intricacy of how the law understands the nature of land and interest in land in all its, you know, various aspects that we're going to look at in the different topics in this course, which comprise the tableau of land law to an Australian lawyer and to a common law lawyer, if you want to put it like that, because it's not just Australian law, that Australian lawyers will recognise what we're doing. But this is about something, you know, more significant in terms of social tensions and societal tensions and conflicts. Okay, so land is a fundamental unit in terms of doing anything, basically. So if, you know, even just at this initial stage, before we even get into all the detail of land or whatever, what can be done without land? You and I and Grant and whoever else joins us, not too many, it seems, given the day and the timing of the class. But anyway, we're all somehow occupying some land, space, right? Wherever we happen to be. We cannot function in the world without land. It's not possible. We can talk about doing things as we do through this course and through your learning, through the e-space, right, and electronic and whatever. But you still need to be physically somewhere, and you still need to be using equipment. We haven't quite got to the stage where we live within virtual bubbles and do everything virtually, right? So that, as we've seen, for example, in foundations, that, I mean, the devices we're using, that's personal property. But the space that we're occupying, both in terms of what we're actually sitting on and the actual space above the surface that we're sitting on, as we know from the topic in foundations, all is a part of what the law understands to be actually what can be land. And this idea of how land is to be used and for what purpose is a driver in terms of how a society evolves. And then this idea of efficiency, so you can break this question down. So you've got the idea of land use on the one hand and land rights on the other. That is use, utility, usefulness, what you can get from it, how it can be used. Land rights on the other, who has entitlement, who has a claim, why and upon what basis would the law recognise that assertion of a claim. Now, when we get to the second problem question, we'll see in some respect, and you've posted a response to that, Margaret, which is interesting, in terms of native title and Aboriginal and Torres Strait Islander peoples. But we can talk about that more generally in terms of rights and claims and what is the basis of being able to assert that, right? But then we got that tension there between the use of land as opposed to the rights with respect to land. But then we've got another tension between efficiency and equity. Now, that's a classic tension, isn't it? And it's not just something that comes up, of course, in this course or in your legal studies, your law studies generally, although it is I would suggest to you an abiding theme often in many of your law units. But it's a bigger, or I call a big ticket item that's out there in society and in the community. Are we concerned about doing the most we can with what we have? Are we concerned about getting, the maximum out of a resource, right? Maybe in a if we talk about, in more sort of theoretical terms, in a utilitarian sense, the greatest good for the greatest many, for example. Is that what we're concerned about? Or are we concerned about this idea of equity? That everyone has a right, an entitlement. Now, in the context of land, surely it's arguable that everybody in a society like we inhabit, all of the peoples of this country, have a right to space, to live and to function and to exist and to be in however they want to be, both in terms of their personal life and their public life and their business and their professional life. Surely that is something that this society can accord people.
And I think the right to enjoy, particularly around environmental purposes and uses of land.
Absolutely. That's a very good point. Yeah. But what this then harks back to, these fundamental tensions, is something that I raised back in Foundations and which comes up again in this course in different ways, and I do that unashamedly, is again this tension between private and public. So in the area of land, and this is why land and the law that governs land and what can and can't be done with land and the interests in land and how one can transfer those interests or dispose of those interests or protect those interests or whatever, becomes so important. One, because land is actually a very valuable thing and it's become extremely valuable in some parts of this country. But it's also about this ongoing tension between private and public. So on the one hand, for example, just to throw out there a hypothetical, for example, in residential Sydney, for instance, which has now become one of the most expensive places in the world to live in, actually, you can't actually have a fee simple ownership or a fee simple entitlement, a fee simple claim recognised according to land law of Torrens title block of land with a dwelling on it in residential Sydney, unless you have at your disposal, either directly or as a consequence of borrowing, and for most people it's borrowing, many hundreds of thousands of Australian dollars. Many hundreds of thousands of Australian dollars. That will give you that claim of a fee simple interest, right? But of course it will also, for most people, create enormous debt obligations to a financial provider. But that's valued, and there's a great insistence upon that within our society today, and that constitutes private ownership. And it's spread not only in Sydney but across the country in different levels and whatever. But the interesting thing is that you can't actually, go back to your point, Margaret, of enjoyment, you can't actually enjoy that private ownership unless you actually have access to public facilities. So you can't do anything with your dwelling, whether you're talking about residential accommodation or commercial accommodation or anything else, if you've got a dwelling on it, within built-up environments, for example, and we'll talk in different ways about open tract land and so forth in regional areas and non-metropolitan areas. Unless there are sorry.
Yeah, I was interested in the whole theme of the commons as well.
Yes, and that's very important. That's very important. And hopefully we'll get a chance to address that as we progress, and specifically it'll come up, I think, toward the end of the course, but hopefully before that. So you need access you need access. You need to be able to access public utilities, water, electricity. I mean, look at us now. We are connecting with each other electronically because we have uninterrupted electricity supply. I just watched a movie with one of my kids yesterday that looked at a circumstance where how do you function if all of that ceases to be? Well, life becomes a very different proposition. So there are all these public utilities that help us to function the way we do. There are access to public land, roads and so forth that allow us to function. But the interesting thing is that there's a disproportion of value placed upon what is private as opposed to what is public. And then there's also this issue which goes beyond this course, is too far outside of this course, and that is the issue about the extent to which people are prepared to contribute towards that which is the public, which supports what is privately owned and enjoyed. The issue about land rights, of course, touches upon the broader concern of the wider number of groupings within our society, including, of course, Aboriginal and Torres Strait Islander peoples, and how one accommodates that in terms of entitlements within the current system of law that we have. We know that native title is a mechanism for that accommodation, but not necessarily without its issues. In this topic, you will see that the legislation under the Native Title Act, as amended following the Whip Peoples case in 1998, provides the framework for the recognition, as was spelled out in Western Australian Ward and also FASO. It provides the recognition, it provides the foundation for native title in Australia today. But it also provides the basis for extinguishing native title. And we've seen in that case law that grant of fee simple interest will extinguish native title, as will other things. We've seen in Whip Peoples and we've seen in Western Australian and Ward that a pastoral lease is not a general law lease and doesn't provide exclusive possession in the nature of what is the defining characteristic of a general law lease, but it's a statutory instrument and it doesn't defeat native title. And so we have to find some accommodation there between these different claims. But the interesting thing about pastoral leases is, historically speaking, and I've given you something in the materials on the course website about a new version of a pastoral lease, for example, in Western Australia. It's proposed for 2015. But the interesting thing about a pastoral lease, historically speaking, is that they're actually about people going out into far-flung areas of this nation or this country and squatting on that land, almost, you would argue, without permission, and then asserting rights as a consequence of long duration. And now believing that this idea of a pastoral lease gives them what a general law leasehold interest gives, that's a long way from what they originally asserted from those original acts of the original pastoralists, or squatters as they were called.
Yeah. I was really interested in reading that, particularly for question 2, and looking at some of that correspondence between Lord Grey and the Governor, I think, of New South Wales at that time, and talking about pastoral leases and that whole notion of leases or licences, and still taking into account the rights of the native population in terms of their coexistence, if you like, with those lands opened up for pastures. Yeah. So I just thought that was really quite interesting, because I think I mentioned in question 2. Yeah, well, if we move on to problem 2, because I think that we've done problem 1, and your response there was nice and interesting.
insofar as you're referring back to that early correspondence, and particularly that distinction between a licence and a lease, and what a pastoral lease meant before we even get to the nomenclature within the Native Title Act of non-exclusive and exclusive possession. Before we even get to that, the other reason I've put this quote here, I think, is it's also important, this distinction between, Grant's bathing a 2-year-old. Oh, that's okay. So that's it. He's having fun. That's great. But he'll hear what we've got to say, and the recording will be up there in due course. So that's family responsibilities are important. The point about this distinction, or the reason I put this question here and given it the focus that I have, is because, as you identify, Margaret, that distinction between licenses and leases, and then also, as I said, the pastoral lease, it's really, that becomes even very important when we actually get to the topic on leases a bit down the track. I think I've made it topic 7. And it becomes important because there is this distinction in the common law and the general law between what is a license and what is a lease. And the reason there is that distinction is because a lease has particular meaning and it confers particular rights. And one of those, which comes out of these cases we're looking at in the context of these High Court decisions looking at native title and pastoral leases, and the history that you've also gone through and had a look at, is that a lease, the quality of the interest that a lessee has under a lease according to the general law. And I'm not talking here, for example, about residential leases according to more recent residential tenancy legislation that's been enacted, but I'm actually talking about general law leases, okay, and the general common law that governs leases. Now, Aisha has joined us. Welcome. One of the key defining elements is exclusive possession. That carries through in terms of other types of leases, for example, residential tenancy agreements, for instance, where the lessor or the landlord cannot interrupt the quiet possession or the quiet occupation of the lessee. And we'll see that more down the track when we get into that topic in due course. So that's the reason it's come here. But can you just say a little bit more, Margaret, about that history, that you mentioned in terms of correspondence and how you interpreted that?
Well, when I looked at that, and I'll just sort of look back to what it said in the text, and the correspondence between Earl Grey, who was Secretary of State, and the Governor of New South Wales, it talked about the concern that pastoral lessees might abuse their position with respect to Aborigines who had traditionally used the land. And there was an order of the council made in 1849 putting into pastoral positions. Page 547.
Thank you.
Second paragraph from the bottom.
Yep, that's good. Thank you. Yep.
And so I just looked at that, and that they were talking about securing the peaceable and effectual occupation of lands and preventing the abuses and inconveniences incident there too. So I looked at that in some way, and I sort of inferred that might mean the possibility of coexistence between pastoral lease and the Aboriginal interests.
Yeah, and that also at the bottom of 547, in context of talking, you also raised this issue about waste. The reference there to the Sale of the Wastelands Act Amendment Act 1846, which was imperial legislation, but at the bottom, right at the bottom of 547, where again referring back to that exchange of communication between the imperial powers in London and those in Australia or in the colony at that time, to give only the exclusive right of pasturage in the runs, not the exclusive occupation of the land as against natives using it for the ordinary purposes. That's the point I think you're trying to make, isn't it?
Yeah.
Now, in the modern version, if you like, version or incantation of the pastoral lease, which is the point that's actually picked up in...
Is that Ward in Western Australia?
Yeah, that's right, in Ward's case. Where is it? Is it in Ward's case or?
I think I did look at that, and I thought, well, they then went on and with the amendments to the Native Title Act, to me, as a result of that case and others, but they then really started to.
No, I'm referring back to Wick Peoples and to Gaudron's judgment. And if you go and have a look at my notes, then it's on page 26. So just above the icon of important on page 26, Gaudron said that the pastoral leases were statutory devices to serve the conditions of the time in colonial Australia. Well, they certainly have a continuing relevance and a continuing role to play. But she goes on to say also there was nothing to suggest that the pastoral leases actually conferred exclusive possession. And then on page 27, at the top of page 27, she says that the vastness of the areas which might be made subject of pastoral leases and the fact that inevitably some of them would be remote from settled areas militate against any intention that they should confer a right of exclusive possession, entitling pastoralists to drive native title holders from their traditional lands. Particularly is that so in a context where, in conformity with the prescribed form, the grants were expressed to be made for pastoral purposes only.
Yeah.
Now that goes back to I think, a statutory recognition, and also in the form of pastoral lease that was ultimately developed, of this idea that what the pastoralists got was something, a right with respect to pasturage of the runs.
Yeah.
So it was not exclusive possession of the whole land. That's the whole point, right? And because it wasn't exclusive possession of the whole land, it actually wasn't a lease in the way that the general law or the common law understands what a common law lease is. It was called a pastoral lease, and we also know today, of course, that there's a definition of a lease even in the Native Title Act. Right? But this is where we've got to be very careful. So the terminology, what does it mean in the context in which it is being used? So it's called a pastoral lease. That doesn't necessarily mean that it is a lease according to what the common law or the general law understands what a lease is. And exactly in this case, or in these couple of cases, High Court decisions, we find the court coming to the view that, in fact, it's quite clear that these pastoral leases are not leases and they do not confer exclusive possession of the total land mass over which they are granted. Because the other thing, as Gordon points out, they are over sometimes huge areas of land in WA and in Queensland for the nature of what the pastoralists are doing. You know, they're running herds of cattle, sheep, on large tracts of land that aren't very arable. So, they've got to move them around and this sort of thing. And your idea, Margaret, of an accommodation, going back to those original communications and as incorporated in, for example, orders in council and these sorts of things, I think that's right. But, of course, the pastoralists didn't want to concede that point because they got this far and they wanted to press home the point that basically what they had now was a right of exclusive possession of the thousands of acres under which their pastoral lease applied to? And that would have been just astounding, actually, in truth. And the other thing is, how would they have enforced exclusive possession with respect to such vast areas? You know, and for practical purposes today, not historically, but today, pastoral lessees have to patrol and have are only able to cover all of their property by helicopter, for example, because it's so vast. How on earth they did it back in the 19th century, I don't know. I think maybe the whole...
But I think part of that whole thing about then dispersal of the native population and the role of the native police assisted in that as well.
Well, that's true. That's very true. That's very true. All right. Did you want to say anything further on the first part? Problem 2?
Sorry?
Do you want to say anything further on the first part?
Where they were saying it was a controversial decision,
yeah,
because it was unexpected that, you know, the decision that pastoral leases didn't equate with exclusive possession. I found that it really wasn't a controversial decision if you look back to the earlier correspondence.
Yeah, but it was controversial in terms of the balance of economic interests, wasn't it? Because of what pastoralists do with their land. Okay, so this is where we you know, the legality of what the law gives on the one hand, as opposed to the implications of that understanding on the other. So, of course, what pastoralists are actually doing is they're running herds of cattle, they're running, you know, sheep, well, beef. Let's talk about beef and lamb rather than sheep and cattle. That is the meat that is the staple food product for a large part of the population, and increasingly, actually, it's a significant export. Right? And
well, they all say Australia was built on the sheep's back, so just the wool exports as well.
The jumbuck was a very sturdy and robust back, that's for sure, in early Australian times, wasn't it? And have you ever seen the old movie, Hollywood movie that was filmed in Australia, The Sundowner, with Robert Mitchum, over which there was a famous tax case actually as well, but that's an indicator of that. But yeah, I mean that. So you know, that's what was at stake here, and they, you know, the interesting thing is, I think that in Whig people, the pastoralists, of course, this was a case involving the government of the day. Both cases, you know, Whig peoples and also Western Australia and Ward, both involving on the one side a government of the day, or the Crown in right of the government of the day. But essentially, the stake of pastoralists was on the table, and you know, it was almost an assumption that it will. I mean, surely it's a foregone conclusion that their interest can't be defeated. How could you possibly defeat the economic interests of pastoralists, you know, by, you know, potential prospective native title claims or whatever? This also, in my view, harks back to something that was recognised by Brennan of the travesty of dispossession, which has sadly been the story of how Australia has been and the landmass has been developed. And you know, I suspect that they arrogantly believed that there was no way that this could not take priority. It could not be the interest or the claim that it was impossible to defeat it. But as you quite rightly say, by going back and carefully examining the legality and the legal basis, one understands that that's not actually what was given. Now, the High Court judges, you know, they've got their eyes closed about the consequences and the implications of what's going on here. And that's why understanding, you know, the ratios, the rationales that come out of High Court judgments, They're steeped, of course, in legal reasoning and judicial process, if I can use that sort of way of explaining it. But they're not blind to the implications and the consequences of their decisions. No? But they are focusing on how the law should and appropriately be interpreted. The other thing one must remember about Justice Gaudron is the first female appointed to the High Court of Australia. And that doesn't stand there blinding her to everything else, because she's otherwise, she was an excellent jurist and lawyer. But and these other factors, I want to suggest to you that they're a part of the mix at the end of the day, part of the mix. And thankfully, we understand today that law evolves with understanding these dimensions that are in play. But it is true that the judges are pursuing their job and their exercise by focusing on, the legality and the legal context they're considering, and trying to determine what should be the best outcome in all the circumstances through that process. And I think that sometimes what happens is people get ahead of themselves. That's what happens. And they are trying to assert more than the law has actually given them, because they have not paid sufficiently careful attention to the nature of what they have, and because that doesn't happen until what they have is actually challenged.
Mm.
Yeah.
One of the things that arose too on page 546, the third paragraph from the bottom, where it talks about the issues in the appeal of the Wick case.
Sorry, say again?
It's page 546.
Yes.
Third paragraph from the bottom.
Yes.
And it talks about a sub-question.
Yes.
That argument wasn't addressed. No argument was addressed to that question in court. And the question was whether native title rights are constitutionally protected by reason of undertakings given by colonial authorities in the mid-19th century. So to me, it came back again to some of that dialogue around that was happening around pastoral leases. Yeah. But I was interested, as to why there was no argument raised in relation to that. So
that's interesting, and I suppose for political reasons, it would be difficult to accept that a constitutional protection within the Australian Constitution might be based on communication between former imperial and colonial authorities. But having said that, constitutional lawyers, true and proper, take a different view on this, but I have actually taught constitutional law. One might suggest, of course, that such things could be a basis for an implied right. Now, the court hasn't done this in the past. It's tended to take implied rights from existing structures within the framework of the Constitution itself. But that, might be an interesting argument. But again, I think what everyone would like to see is a more open expression of a constitutional enshrinement of the position of Indigenous peoples, through actual express provision within the document itself. But that's an interesting point that was raised, but not taken up an argument before the court, and therefore the court can strictly just say, well, it's not there, we don't have to address it. But nonetheless, an interesting issue. How about we move on to the second part of problem 2 with regard to this idea of non-exclusive possession and exclusiveness in possession, and or what that means. Want to make a comment on that? Or Aisha? Is Aisha there? Are you with us, Aisha?
I am. Hi, how are
Okay.
you? I'm sorry I was late.
That's all right. That's all right. Would you like to comment on the second part of problem 2, topic 1?
Yes, hang on. I've just got it in front of me. I've got to split the screen.
That's all right. Can you just turn up your sound a little bit?
Yeah, I can. Can you hear me better now?
Yeah, that's better. Yep.
Right. We're still talking about the Wick case. Is that correct?
We can be, yes. Wick or, yep. Western Australia and Ward, really. This is a quote in Western Australia and Ward, but it links back to Wick, but it's really, this is in Western Australia and Ward because this idea of non-exclusive possession was introduced as an amendment to the Native Title Act following the Wick decision.
Okay. I read some of the Wick case, but I did not read the Ward case, so I'm afraid I can't comment on that.
All right. What about the idea of possession? Can you comment on the idea of possession?
Yeah, well, in what regard? Or
well,
from what?
Well, this idea of exclusiveness, I mean, is that, how do you understand this idea of exclusiveness in the context of possession as a property law concept?
Okay, I guess the principle that underpins possession is that apart from possession being prima facie evidence of ownership, that whoever is in possession has the best title at that time unless somebody else can prove a better title. So would that be the principle underpinning possession that you're referring to, or am I completely off track?
Not quite. Margaret, do you want to make a comment?
In terms of the possession, I suppose I took it to maybe look, as I said earlier, about earlier colonial laws and the possibility of like shared possession and non-exclusive possession. So that was kind of like the angle I was coming at more than what exclusive possession might be, because I just really felt that the emphasis on that, it was taken without really considering some of the earlier laws and land laws and, the Mitchelton laws and whatever that were around in 1910 and going forward.
Yep. I'm just for those of you that are with us, maybe if you can just pull up the Native Title Act on Austlii and go to section 4, because what's happened here is that section 4 was amended after the Wick People's decision. That was one of the amendments that was introduced in the amendments to the Native Title Act, right, that the Howard government introduced in response to Wick People's. Now, if you go to subsection 6 in section 4 of the Native Title Act, just read subsection 6. Now, first of all, has anyone who's online with us got a comment about just the wording of that section, that subsection of 4? So 4 sub 6, any comment about the wording of that subsection? Sigan, welcome.
Mark?
Just mute. So again, if you can mute your microphone when you're not talking, please.
Okay, thank you.
Just mute the microphone when you're not talking. Thank you.
So, Michael, you were saying it's, I sort of was jumping ahead of you. So it's under the Native Title Act, the amended Native Title Act, you were saying?
That's right.
Okay. I just went back to my question and I was looking at what the amendments really introduced, and it was that concept of the exclusive and the non-exclusive possession.
But what does the language within the subsection for subsection 6? How do you respond to the language of that?
Hang on, I haven't gone there yet.
Okay.
I was reading.
That's all right.
Reading the response to my
Let
question.
me read it to you. I'll read it to you if you can't get it. So under subsection 6, it says, this Act confirms that many acts done before the High Court's judgment, of course it's referring to Whig peoples, that were either valid or have been validated under the past Act or intermediate period Act provisions, will have extinguished native title. If the Act are previous exclusive possession acts, the extinguishment is complete. If the acts are previous non-exclusive possession acts, the extinguishment is to the extent of any inconsistency. I mean, what is the Parliament trying to do here, for goodness sake?
To me, it looks like they're trying to extinguish native title as much as possible. That's just what I get from that reading. But to be quite honest, I still don't get it.
It's the wonderful example of the Parliament being elliptical, right?
Mm-hmm.
Using slippery elliptical language, because basically what they're trying to do is they're trying to say, all right, we've got Whig peoples. That's not what we wanted. We didn't want Whig peoples to be that's the outcome of a conflict between pastoral leases or the interests of pastoralists and native title holders. And somehow we've got to accommodate Whig peoples, but we have to do it in a way that tries to redress what we believe to be a better balance to be struck. So they've introduced this idea of exclusive and non-exclusive possession, and as the judgments say in Western Australia and Ward, to some degree they're creating a bit of a fiction here. I mean, if you've got possession, surely you've got possession, and surely possession means exclusive possession. That's how the law normally understands it, right? How do we come to terms with these ideas within the legislation? Well, of course, the problem here is that when the Parliament acts and intervenes and legislates, we must respond to that, and we must recognise that, and we must give it an interpretive response in some way. So the courts have to respond to it. They can't ignore it. They can't say, well, that's nonsense. We're not going to do anything with that. They have to somehow respond to it. And so if the general law position was otherwise before the enactment of this provision, then this provision affects or changes the general law to the extent to which this provision, that's section 4.6, affects whatever area it touches. Now, it doesn't obviously touch everything, but insofar as it's touching and affecting and regulating the interests that it relates to, then maybe it has created something new that didn't previously exist under the general law. And that is this idea of a non-exclusive possession act. An exclusive possession act, or a previous exclusive possession act, and a previous non-exclusive possession act. But the language is very, very awkward and very elliptical in terms of how it tries to do what it's trying to achieve. So that's also something that the courts can respond to and say, well, how does this work? And then they can seek to interpret it within the factual circumstances that apply or don't apply, and so on and so forth. And
the other thing for me,
sorry, Margaret.
The other thing for me too was, what was read from the legislation was a totality of extinguishment.
Yeah.
And I think the more that we can look at it, that may not necessarily be the case. In terms of if it's extinguished, it's gone forever. And I know that, like in Yorta, that was, I think, one of the things that came out of that. But I'd like to think that there could be more work around that as to, what is extinguishment.
I think there needs to be a lot more work around that in terms of getting an understanding of this distinction between previous Exclusive Possession Act and previous Non-Exclusive Possession Act. I think we need a lot more clarification of that. But the point that we're getting to through that second problem question is that, to some extent, this nomenclature or this terminology causes, as McHugh points out, a contradiction in terms, because possession has been seen historically as giving the right to an exclusive occupation, if you like, or exclusive entitlement. So that in the context of a lease, we talk about exclusive possession, right? And we certainly don't talk about an exclusive possession act and a non-exclusive possession act, But as I said, when the legislation acts to create something that may be new, well, the law has to, the courts have to respond to that in terms of how that then governs this area. And we know that native title is governed by the Native Title Act, not by the previous court decisions that predate the legislation. And where the legislation has been amended following court decisions, we must look to that amended legislation in the first instance, and then to whatever extent the previous decisions can sit with that amended legislation, that's the extent to which they continue to bear authority in law. And that's the relationship, as we know, between the law that emerges from the Parliament on the one hand and the law that emerges from the courts on the other. Now, the interesting thing in land law is that, and we'll see this as we progress through the course, is that we have this, what I call almost at times, one can talk about the dance macabre, if you like, between the legislative will on the one hand and the work of the courts on the other in terms of general provisions and general law. And why do I call it a dance macabre? Because the Parliament doesn't always conclusively legislate with respect to something. Sometimes it just intervenes in a piecemeal way. Sometimes it intervenes in different respects. It doesn't comprehensively take over everything and replace all of the previous general law. And so what you're doing is you're working between general law concepts and legislative provisions very typically, and that's very much within the heartland of land law. We also will see, as we progress in this course, the dance between common law and equity, which continues, even in the midst of the spectre of Torrens title, if I can use that sort of melodramatic way of putting it. This jockeying between common law and equity still very much at play, even with respect to Torrens title land. And of course, in Queensland, we only have Torrens title land. We don't have general law land anymore. All right. Any open comments, questions, issues? at this stage.
I have a comment, and that is that I think with property law and land law, I struggle with the subjects because to me they're quite abstracty and conceptual. So I do struggle understanding this.
Just to comment on that is the foundations course probably was a bit more like that than land law will become, as you will see. Land law has a lot of practical edge to it, but we are still dealing with the principles of land law rather than the practice of land law, such as emerges through, conveyancing, for example, is the day-to-day process of, transfer of interests in land and the acquisition of interests in land and so on and so forth. And, in my course, conveyancing, that's something we do. But so, it is one step removed from the actual transactions itself. However, it's very much involved with transactions and dealing with interests affecting land. So to that extent, it's more practical, I suppose, than the foundations course was. But yeah, I don't those challenges that you've hinted at. Yes, they're there, and I think all students find property law a bit of a challenge first up, and it's a challenging area. And one of the reasons for that is because it's unlike several of the other areas of law that are really governed by more modern legal frameworks. There's a lot of history in land law and property law, and there's this jockeying between legislation, common law and equity to a far greater degree than there is in other areas of the law, I think, which is, just general observations that I'd make, Aisha.
Thank you.
But I want to encourage you to stay with it. Yeah. Margaret, any final thoughts?
Yeah, just following on from Aisha's point, I think why I actually like property, well, what we did in the property law and in land law, is the human element. That's particularly in this that we're going to see more of, the humanities, I suppose, of land. And I think what you mentioned earlier about those continual tensions that are there, and that whole concept of land, and then as people how we view land, how we use land, how we enjoy land. Yeah. I particularly like that human element that comes into it too. But I also like the historical side of things too. So
indeed. Thanks for that. That's just a general comment, and bouncing off both of those thoughts. I think a way to keep seeing the practical dimension is, despite the fact that we are immersing ourselves and will immerse ourselves into a complex array of law as we progress through the various topics in the course, keep reminding yourself that at the end of the day we're talking about something that's real. We're talking about parcels of land. We're talking about lots. We're talking about things that are occupied by people to live on, to function from, to raise families, to have relationships in, to run businesses, to carry out their jobs and their professions, and to have lives. And without land, none of this can happen. And it doesn't matter whether you're living in a metropolitan area, whether you're living in a regional area, or whether you're living in a rural area, the structures and the settlement of these places will not be the same. But one thing is absolutely certain, that without land, nothing can happen. That's the wonderful fascination, in my view, of land law at the end of the day. But of course, I suppose I'm a little bit biased. Anyway, So there we have it. An introduction to land law, to the concept of land, to native title as understood according to the Native Title Act, and also the processes whereby native title can be extinguished. Next week, we turn our sails into the gale of the Torrens system, and we will spend 2 weeks, really more than 2 weeks, because Torrens will haunt us throughout the course, but we'll spend 2 weeks coming to terms with what is Torrens title land, and what does indefeasibility of title mean, and does it hold out all that it suggests it hold out, or in fact are there things, you know, picking away at the edges of it that are making it a bit more fragile than what it, you know, appears on the surface. So fun and games await people as we move forward next week into topic 2, looking at the Torrens system. So hang in there and enjoy. Bye for now.
Okay,
Bye,
thank you.
thank
Good night.
you.
Bye.
Thank you.
All the best.
G'day, Michael.
Oh, Grant's there. How are you?
Not too bad. How are you going?
Do you want me to leave the recording on, or I turn the recording off at this point? What do you want to
Oh,
do?
no, you can turn it off. I'm just going to say I should be on